Ladies and gentlemen, it's Ansel Glink's Quorum Forum podcast. It's me, Dan Bolin, in the chair. We're taking a little summer recess this month, but that doesn't mean we're short on good government information. In fact, we're taking this opportunity to re-release one of our most popular and practical episodes, Tips for Newly Elected Officials. This special re-release is to celebrate the launch of the brand new Ansel Glink 2025 Guide for Newly Elected Officials, which is now available for you to check out in the Resources tab at anselglink.com. The brand new anselglink.com if you haven't visited yet. The 2025 Guide for Newly Elected Officials is a fantastic resource for anyone who ran for office in the April 2025 elections. It's written to help officials understand the whole series of laws that govern their duties. It covers descriptions of Illinois governments like municipalities, park districts, school districts, special districts, fire protection districts, libraries, and townships. Plus, it offers 25 insightful articles on key statutory requirements and practical problems applicable to all units of government. These include vital areas such as the Open Meetings Act, the Freedom of Information Act, financial matters, ethics, labor issues, construction law, governmental litigation, intergovernmental cooperation, and technology. Of course, Ansel Glink, with nearly 100 years of experience, literally wrote the book on local government law and continues to provide extensive resources for our public sector clients and friends. Now, this recess episode, this is tips for newly elected officials. This podcast dives into some real nuts and bolts advice directly from Ansel Glink's attorneys. You'll hear practical insights on the Open Meetings Act, the Freedom of Information Act, your role as an elected official, and social media use. I think this episode is packed with useful information, whether you're brand new to office or a seasoned veteran looking for a refresher. So sit back, listen up, and get ready to learn more about doing good work for the people. Engineer Rick, roll it. The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast. The podcast, Local Governments Need to Do Business. In the chair, it's me, Daniel J. Bolin. On the agenda today, it is tips for newly elected officials and not so newly elected officials. We have a lot of good government advice, Open Meetings Act, Freedom of Information Act, some real practical nuts and bolts from Ansel Glink attorneys. But first, let's take the roll. Engineer Rick is here. We have a quorum. Without further ado, gang, it is a regular meeting. We do have to have public comment. We opened up the Quorum Forum hotline for public comments from Ansel Glink attorneys with tips for newly elected officials, and we got a bunch of good tips from Ansel Glink attorneys Adam Simon, Dirk Price, Aaron Monforti, Julie Tappendorf, and my close personal friend, Dan Bolin. We've got lots of helpful tips we have tips. We hope you'll find they're helpful. And without further ado, we're going to play some the voicemails we received on the Quorum Forum hotline with the tips for newly and not so newly elected officials. And so without further ado, Engineer Rick, roll it.
Hi, this is Adam Simon, calling to give some advice to newly elected officials. My favorite piece of advice for a newly elected official is to make sure that you don't try and become the boss of the rank and file day-to-day employees. They only need one boss, and their boss is the manager or administrator for your agency. Your organization cannot function effectively if every elected official is directly contacting staff and setting different goals and priorities. The day-to-day operations of your agency need to be delegated to the manager or administrator, and their jobs to implement the goals set by the entire board. So good luck. Thank you for volunteering to serve your local government, and be well.
Hi, this is Julie Tappendorf from Ansel Glink. Tip for newly elected officials: think before you send that text or email about government business. Do you want that email or text to be on the front page of the local newspaper or printed on social media? Most communications about government business are releasable under FOIA, so they're going to be publicly accessible. So think about that before you send. Sometimes picking up the phone can be the best way to communicate about public business.
Hello, Quorum Forum listeners. This is Ansel Glink Associate Erin Monforti. If you are a newly elected official, congratulations and welcome to the wonderful world of local government. My favorite tip for elected officials, new or incumbent, is to make sure that any rules for public comment during meetings are enforced uniformly during each and every meeting and without regard for the speaker or the content of the speech. Section 2.06G of the Open Meetings Act requires that public bodies provide an opportunity for any person to address public officials at open meetings, subject to the rules established and recorded by the public body. Different courts, including the Seventh Circuit Court of Appeals, which has appellate federal jurisdiction over Illinois, have heard many cases involving First Amendment challenges to procedures for public comment at government meetings. Courts typically use a legal test called forum analysis to determine whether restrictions on public comment are constitutional. I'm going to share a few tips and guidelines on permissible restrictions on public comment. First, the rules that you promulgate for public comment should only regulate the time, place, or manner of the speech, not its content. Viewpoint discrimination is generally regarded as the antithesis of free speech, and content neutrality is important to preserve the marketplace of ideas protected by the First Amendment. Second, any rules must be narrowly tailored to serve a significant government interest. This means that a government must have strong, evidence-based reasons for restricting speech, even when the restriction relates to the time, place, or manner of the speech in question. Third, if a speaker is determined to be reasonably restricted in his or her comments, there must be ample alternative channels of communication for them, meaning that the speaker is afforded some fair opportunity to address his or her intended audience. Of course, you should always contact your local government attorney for specific questions about managing public comment. There are plenty of ways to make sure your constituents have a fair opportunity to be heard while maintaining order during public meetings. Keeping consistent, justifiable rules that are enforced even-handedly is important for avoiding claims of free speech violations during meetings. Thanks for listening, and I hope you have a wonderful, safe, and productive summer.
Hello, and congratulations, newly elected officials. My tips for you, and this is Dirk Price, are only a few to bear in mind. One, you have no power individually. Unless you're maybe a new mayor, you have a little bit. But mostly all your power comes from being together and acting corporately as a corporate body. That's why the Open Meetings Act is so concerned when you start to get together with others who are also elected to the corporate body. That's when you start to aggregate power and can actually do things. Until you're together and act corporately, you really can't do anything. Can't direct an employee, can't bind the unit of government to anything, can't change something, under your jurisdiction. You have to act corporately. So figure that out, how to work together in the sandbox, because that's the only way you can accomplish something, and then be aware that when you do work together, it needs to be open in the sunshine and public. My other tip for you is really pay attention to your social media now, because without knowing it, you can inadvertently turn it into a public forum for government purposes and lose control of it in that way, so that all comments have to be accepted. I recommend to you my partner Julie Tappendorf's book on social media and the government, but those are my tips, is pay attention to your social media in a different way than you did before, and remember, you're stronger together because you don't have any power individually. Okay, bye.
Hi all, this is Julie Tappendorf from Ansel Glink. I wanted to give a tip to newly elected officials who use social media to engage with their constituents. Probably the best practice tip I can give you is to keep your personal social media activities separate from your government activities. And that should avoid turning your personal Facebook or Twitter account into a public forum that would then be subject to First Amendment censorship rules where you couldn't delete negative comments. So keep the pages separate. If you need to create a government page, I encourage you to do so. And thanks for listening. Bye-bye.
Hey, Quorum Forum Podcast, Dan Bolin calling. Just with some tips about the Open Meetings Act. I got like 10 general tips about the act that I wanted to talk to y'all about. I'll drill down on just a few of them, but the 10 that I'm talking about, number one, meetings are presumed open. And two, you got to know what the definition of a meeting is, so you know what triggers the formal requirements of the Open Meetings Act. Electronic communications, those, be careful about those. Those could trigger a quote-unquote meeting. Electronic participation, your organization probably has adopted rules to allow members to participate remotely when there's a physical quorum present. Annual schedule of meetings, you got to have one to let the public know when all your regular meetings are. You got to post an agenda, have the right content on the agenda. Use your emails, again, electronic communications, an emerging and important issue in Open Meetings Act issue. Closed session, know when you can go into closed session and honor that narrow purpose that you're in closed session for. Recordings of your meetings are allowed. You can adopt reasonable rules to govern those. And public comment, got to allow it in every meeting, an opportunity to adopt to address the public body at every meeting. But you can enforce public comment rules, but they have to be adopted, and you should make those available to the public so everybody knows what the rules are. We're going to drill down on a few of these Open Meetings Act issues. Number one, what is a meeting? Well, it's any gathering of a majority of a quorum of the members of the public body held for the purpose of discussing public business. So a gathering, like any gathering, whether electronic or phone conference, video conference, a physical in-person meeting, that's a gathering of a majority of a quorum. So quorum of, say, a 7-person board might be 4 members. The majority of the quorum would be 3 members. So anytime 3 members of that 7-person board are gathered, that might be a meeting for purposes of the Open Meetings Act. That means that 2 people could talk to each other about public business, and that's okay. But 3, you got to observe the formalities of the Open Meetings Act. And again, for the purpose of discussing public business, staff meetings aren't, they're not members of the public body. That is not a meeting. Political rallies, that is not public business. That is an outside organization type thing. Social events. Your social, you're getting together socially. Not talking about public business.
if you are, you might be required to observe the formalities of the Open Meetings Act, and it would be a very, maybe, kind of boring social event. I don't know. I love public business, that's why I do it. But in any event, not all gatherings are going to be meetings. If a meeting does fall under the requirements of the Open Meetings Act, you're going to need to post notice, an agenda, keep minutes, have the meeting in an open and convenient location. You have to allow public comment, and you're going to have a physically present forum to do business, unless there's special exceptions to the law apply. Again, it talked about electronic communications, email. Don't use reply all. Why? You've been on a reply all email that you didn't need to be included on. You didn't want to be included on that in the first place. It's just good etiquette. But also, too many emails sent contemporaneously to everyone on the board could arguably be considered a meeting that wasn't properly noticed and open. Certainly, if you're not included on the email, it's not open and convenient. But so be mindful of how you use email as an elected official. Instead of using reply all, this is a great way to use staff and cooperate and collaborate with staff. This is a great role for staff, kind of moderate questions and get the correct answers. Just if you have a question about an agenda that was sent to everyone, reply just to staff, and they can direct you to the answer rather than opening up the possibility of a communication to everyone that might be misconstrued or construed as a meeting. Electronic participation at meetings, you got to have a physically present quorum. The special pandemic time rules, at least today, are the governor's disaster declaration supporting those for meetings without a physical quorum. That's like those meetings where everyone's on Zoom. That disaster declaration is expiring or has expired by the time you listen to this. And the law, maybe the General Assembly is going to act to change it. We'll have to wait and see. But there are existing, like pre-pandemic time, opportunities for members to participate in a meeting without a physical quorum. You got to have written procedure. There are statutory reasons for the physical absence. It has to relate to illness or a business or emergency, not vacation. The approval is required to authorize the remote attendance, and there, again, must be a physically present quorum. Agendas, what's on the agenda? You got to post the agenda 48 hours before the meeting. That is a continuously available 48-hour period before the meeting. It is calendar hours, not business hours. That must be provided to the local news media if they requested it, and must be posted on the website if you have one and have full-time staff. The agendas must set forth the general subject matter of any ordinance, any resolution or ordinance that will be the subject of final action. And any matters that are for consideration for final action should be included on the agenda as well. adequate amount of detail about what that's going to be to put the public on notice about what's being considered for final action. For example, possible action after executive session on the agenda isn't good enough. A more descriptive item on the agenda is going to be required. Public comment, again, any person is permitted an opportunity to address the public body at a meeting under rules established and reported by the public body. So that means public comment can be limited, but you have to have rules first and should be written and adopted by the public body. Public access counselor says public comment must be provided at all meetings, and it applies to subsidiary bodies too, not just the city council, but all the various boards and commissions that your local government might have. You got to establish and adopt written rules. If you want to be able to enforce the rules, they need to be written and established and adopted. You can establish time limits for public comment, and you can enforce rules on decorum. And public comment can be at any point during the meeting. You could do it at the beginning. You could do it at the end. You could do it in the middle. You could, some communities do it for each and every agenda item. But the opportunity for general public comment, should be provided at every meeting. You don't have to answer questions or respond to comments. I know it's tempting to. You're not required to, but it might be best, to accept the public comments, refer them to staff, and follow up with a fuller, more complete answer next time, or offline with the member of the public. You cannot refuse to allow a person to speak for failure to disclose their residence address. People can disclose their residence address if they want to, but you can't require it. You can't require advance registration to speak during public comment. There's a case where they tried to require 5-day advance registration. That was not okay. And you can't restrict the content of the speech. You can open up public comment for particular agenda items or items on the agenda, but opportunity to address the public body as to whatever, that should be provided at the meeting. And related to the address issue, you can't restrict public comment to just residents only. Just whoever's attending the meeting, member of the public, should be an opportunity to speak during public comment. Quick note on closed sessions. Like most meetings are open to the public. Most meetings are open to the public, but there are certain topics that you can go into closed or executive session to, like related to the sale or lease of property, pending or imminent litigation, hiring, firing, or discipline of specific employees or compensation of specific employees, collective bargaining discussions, or the review of closed session meeting minutes. Those are some common Open Meetings Act exceptions. Keep in mind those are going to be construed narrowly, so you need to the sale or lease of property. It's not just any sale or lease of property. For example, the exception for the sale or lease of public property is going to be, the exemption is limited to just to the price, setting the price for the sale. The decision whether or not to sell the property, that is a public discussion. And pending or imminent litigation really needs to be either actually filed litigation, pending litigation, or imminent. You need to make a finding to support that litigation is really imminent. Even just like the nasty gram threatening a lawsuit is not enough. You really need a finding that the litigation is going to be imminent. So those exemptions are going to be construed narrowly. Follow the rules to go into closed session. Stick to the topic that you're going to be in closed session to discuss. That is, that narrow topic. It's easy to drift off topic, and so a lot of times the attorney or staff will, direct discussion back on topic with the assistance of the mayor, the chair. A motion is required to go into closed session. The motion must identify the exemption. Probably just saying personnel isn't good enough. Like actually, citing the exemption and knowing that it's for to discuss a specific employee. Reciting the exemption is a good practice. A roll call vote is required. This is a situation where a roll call vote is required. You have to keep minutes and record a verbatim recording of the closed session. Another closed session issue that comes up is, what happens if, somebody, a member is invited to closed session and then goes off and blabs about what we talked about in closed session. Well, your fellow council members or board members could censure you for that. But really, it's a practice and the reason why it's a practice to avoid is because, you're in closed session for, those specific purposes, and disclosing that information you discuss in closed session, for example, like real estate negotiations, if, you disclose the price that you're willing to sell a piece of property for, or purchase a property for, disclosing that information publicly outside of closed session before the appropriate time while the transaction is still pending, that could really prejudice the city's or the village's negotiating position, and really actually cause some harm to the municipality's position. So keep the stuff in closed session confidential until such time there's a finding that there's a time to review and release your closed session minutes, and when you find there's no longer a need for confidentiality anymore, that's probably the time that would be safe to talk about that. There is Open Meetings Act training. All members are required to of municipal boards, councils, commissions, got to complete the statutorily required training, Open Meetings Act training through the Open Meetings Act. The Public Access Counselor provides the Open Meetings Act training. That's on their website. You got to complete that within 90 days after being sworn into office. So just some highlights. Avoid emailing, texting, gathering with other members to talk about public business. Don't reply all. when other members of the public body are included on the communication. Remember that the purpose of the Open Meetings Act is transparency in government decision making, and adopt a public comment policy if you don't have one. So those are kind of high-level view and deeper level view of some items to know about the Open Meetings Act. If you haven't taken the Open Meetings Act training, hopefully all this will help you be prepared for it, and you'll do well in the training and in your meetings, open and closed, and do good work for the people. So talk to you later. Hey, Quorum Forum Hotline, it's Dan Bolin calling again. Wanted to leave some thoughts about rules of procedure for local governments. You know, your local government probably has adopted some kind of rules of procedure for its meetings. That a lot of communities adopt Robert's Rules of Order, at least as a backstop to whatever other locally adopted rules you may have. But keep in mind that Robert's Rules of Order was prepared for 300-person assemblies and complex committee structures and all sorts of different things. So they might not apply, all of them anyway, to your 7 or 9-person board. And so you might have members of the public or certain members of your board or council insist on the strict application of Robert's Rules of Order, but the fact is that they all might not apply to your organization. That's something that you should work with your experienced chair or mayor or whoever's presiding over the meetings to understand. And, you know, with the help of your attorney or staff, will help you to understand the best way to get the work done, and not so much get tied up in parliamentary kind of quagmires. But you know, that is the role of the mayor or whoever's presiding over your meeting to, you know, rule on all these kinds of procedural questions and enforcement of procedural rules. Councils can, you know, theoretically censure a member for, you know, violating the rules, but, you know, let's hope it never really comes to that. Your rules will govern voting. Voting must be recorded in the minutes. All votes must be taken at an open meeting. There's no secret ballots for local government meetings, at least in Illinois. A good rule of thumb, when in doubt, take a roll call vote where everybody's name is called out individually and they say what their vote is. There's some things that could be like a voice vote, but roll call votes, you need it when you're spending money, when you're going in a closed session, when you need to specifically identify what everyone's vote is. Consent agenda is another useful tool that can be incorporated into your meeting procedures to help your meetings go more smoothly. That's where, by unanimous consent, everybody agrees to take a single vote on multiple agenda items. And so But before you vote on the consent agenda, any member can request an item be removed and be voted on separately. But the stuff that's left on the consent agenda, you can knock that out all at once. Saves time. It makes more valuable use of your meeting time. Other efficient meeting tips, not necessarily rules of procedure necessarily, but be prepared. Read the packet in advance. It's always in the old days when the packets were in envelopes. It was always a little demoralizing to for staff to show up at the meeting and see the board members or what have you open the packet there for the first time at the dais as the meeting is being started. So being prepared, that's just part of being prepared to, again, make the most use of your valuable meeting time. You can kind of set informal time limits on board meetings. No good decisions are made after midnight or even 10 p.m. if you ask me. There's going to be a meeting, in 2 weeks or next week, or you can find another time when everybody's at their best and prepared and able to address the issues at hand. And that goes to like limiting debate again to make the most of your meeting time. And so those are just some tips on rules of procedure. Good luck. Talk to you later. Hey, Forum Podcast, Dan Bolin calling again with some more tips for newly elected officials. I wanted to talk about some of the roles and responsibilities of officials in municipal government. You've kind of got three quote-unquote branches of municipal government. You've got the executive, that's like your mayor or president, village president. You got the legislative branch, that's like your city council or village board. And you kind of got the administrative branch, which, is usually tucked under the executive branch. Some communities it's tucked under the legislative branch. Check your form of government. But that's the manager or administrator. And so, executive typically is responsible for appointments, enforcement of laws. The executive will chair the meetings, preside over the meetings, enforce the rules of procedure at the meetings. The legislative branch usually sets policy. You're the policy makers. You establish the budget. You provide advice and consent to appointments by the mayor, the village president. And the administrative branch is kind of charged with the day-to-day operations, supervising employees and implementing the policy that is set by the city council or the village board. So the mayor recommends policies, procedures, and programs to the city council a lot of time, drilling down on kind of these roles and responsibilities a bit. Ordinance enforcement, you appoint those officers. The executive branch also kind of has a liaison with city agencies and other governmental bodies, that kind of external role that the executive branch will have. The mayor will have access to all city records to help the mayor and village president do their job, and they perform other duties prescribed by law. You can veto ordinances, a vote in certain instances, a tie vote, when half of the aldermen have voted in favor of an ordinance, even though there's no tie, or where a supermajority vote is required by law. Mayors also have emergency powers, not often exercised, but they were more considered during pandemic times, I would think, in some communities. And they work with the administration. The administrator oversees all the city or village departments, doing those day-to-day operations. He administers your personnel code if you have one. Oversees employee training requirements and programs. Negotiates with unions if you've got one. Usually in charge of appointing, removing directors of city departments with the advice and consent of council, but and financial responsibility usually falls on administration to help with budget prep and do financial analysis, establish procedures for expenditures, and work on finding and organizing funding for different programs. Importantly, the administrator will often attend board or council meetings. Of course, they have no vote. They famously have no vote. I just saw a retiring city manager receive a plaque from their city council. The plaque said, name of manager, but I don't get a vote. Because she would always say at the meetings, hey, this is what I think, this is what I recommend, but I don't get a vote. But council will look to the administrator for those recommendations and advice and help them formulate policy. The administrator also has a role in an ordinance enforcement and may also have other duties assigned by the corporate authorities, that is the mayor and city council. The legislative branch, again, they're the policy makers. They can determine rules of procedure for their meetings. And an important point is that in most municipal governments, their powers are collective. They're not individual powers. And it's important that that you work together. Your power comes together from working with your fellow trustees, working with your fellow alderpersons to come together to determine policy and act with one voice and to determine what the policy is, give that direction to staff or to the administrator or to the mayor to help implement that policy. Again, the legislators, the alderpersons and trustees have access to records necessary to carry out their duties, to set employee salaries. They can have the authority to create offices, and they do provide advice and consent to those appointments. Can't forget about your city clerk. You might have an elected clerk. You might have an appointed clerk. That's a special role in every community. The clerk attends the meetings, takes the minutes, maintains all the books and records of the municipality, maintains the corporate seal, and often signs documents on behalf of the city where directed by council or the trustees. So understanding your role is important for newly and not so newly elected officials alike. Operating within your role, working collaboratively with the other elected and appointed officials and staff in your municipality, and not encroaching on others' roles. Respecting what form of government, what structure that your organization has to get the work done is really important to, really working collaboratively and producing an overall good result for the community that implement the policies that you all set together. So that's a big overview of roles and responsibilities of elected officials.
Wow, those were some great voicemails from the Quorum Forum hotline. We appreciate Adam, Dirk, Aaron, and Julie for taking the time to call, and Dan Bolin. Thanks to him too. He's a good guy. I know him well. And the next item on our agenda is the Department of Public Works. We have upcoming publications, the Newly Elected Officials Guide we are working on this summer at Ansel Glink, helpful compendium of articles that we have ready for fall conferences every year. Keep an eye out for that. Which will have even more helpful tips for newly elected officials. Other speeches, conferences coming up. Looking ahead to the American Planning Association Illinois State Conference coming up in September. I know I'll be there. Planning on having a few sessions there. In the APA Chicago Metro Section bar exam, we're working on scheduling one of those two, one of my favorite events every year. Thanks again to all the Ansel Glink attorneys for calling the Quorum Forum hotline today. Before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@anselglink.com and visit us online at quorumforum.anselglink.com. Hey, you can also call the Quorum Forum hotline too, 312-604-9185. You can always reach us there as well. Can I get a motion to adjourn? So moved. Second, all in favor, the ayes have it. We'll see you next time on Ansel Glink's Quorum Forum podcast.